ನಿಮಗೆ ಅರ್ಥ ಆಗಿದೆ ಅಂತ ತಿಳ್ಕೊಂಡಿದ್ದೀನಿ.
ಅರ್ಥ ಆಗಿದೆ ಸರ್.
Okay.
Thank you, sir.
Okay, let's see. However, you might have got some, critical thoughts on the constitutional law of India. In this session, we can have a look on intellectual property rights, which is highly scientific and technological one. So usually in this title, we have to talk on three sidelined approaches. One is intellectual property, then rights. Later on, we can talk on law. Intellectual property, rights law. These are the captions we have. As and when you deal with intellectual property rights, how exactly property rights should be protected and who has to protect? How exactly intellectual property rights should be protected by the state? Any infringement of copyright, patent, industrial design, integrated circuits, then geographical indications, how exactly remedies should be given to the people who are left out in the society. This is very, very important. And you have to give eyes to the eyeless, remedies to the remediless. All in all, you have. In this context, obviously, if rather I would say, your science and technology, they look as if an eagle flying faster and faster, whereas your law looks as if a tortoise. Slowly, slowly, it's moving. Therefore, with a view to match with science and technology, your tortoise should be rejuvenated. Otherwise, it's very difficult to understand scientific approaches all in all. If you just look into UDHR, Universal Declaration of Human Rights 1948, International Covenant on Civil and Political Rights 1966, then International Covenant on Economic, Social and Cultural Rights 1966. Of course, no doubt in it, scientific temperaments are also protected. Whatever you have created on the basis of your own efforts and minds should be respected. So in this context, we have to understand intellectual property rights, how exactly the creation of mind should be protected. This is one thing. As long as you are dealing with rights, obviously you have to define what is right or what are rights. Rights are nothing but interest protected by law. Rights are interested protected by law. By law in the sense that whatever it could be municipal law or regional law or international law as well. This is what one should understand. With a view to understand the subject matter of law, much has been discussed. I think this is not the right time to understand it. You require minimum 2 years to understand what is law at all. If rather I would say, law is not so simple. It is there everywhere. Even you can find outer space, seabed, subsoil, ocean floor, Arctic, and anywhere. It requires a lot of drill to understand what is right. Obviously, there are some theories which are exposed to understand what are rights. Look at one of the theories, will theory. In will theory, in fact, Hegel, Kant, David Hume, they exposed to say that right is an inherent attribute of a human will. It all depends on will of the people. This is very, very important. Let me share with you on the basis of will theory. In will theory, as I've already been made clear, that Hegel, Immanuel Kant, David Hume, they are the people who could say that right is an inherent attribute of a human will. Yes, I agree with you. It is a human will, which is created on the basis of your efforts. So without rights, you cannot enjoy everything. As I said in the last session, based on Article 21 of the Constitution of India, wherein it has outspoken on primordial use. Article 21 of the Constitution that itself is a primordial right, without which other rights cannot be enjoyed. This is what even the Supreme Court of India came out with its own perceptions in many cases, not even one. Look at the case of the Bharati versus State of Kerala, wherein it has come out with basic structure theory. The basic structure theory cannot be amended under Article 368 of the Constitution of India as such. So in a silver lining, it has been directed. You cannot rewrite the Constitution. You cannot destroy the Constitution. This is what the Supreme Court said. I have not been said. It has been said by the Supreme Court, pronounced by the Supreme Court. 13 judges, they sat together and decided to understand what is to be done in future based on theoretical and practical perceptions are concerned. Look at one of the instances I'm just sharing with you. Why women are possessing more rights? It is because of a historical injustice and practical denials. This is my answer. You cannot say why women are possessing more rights than men. Even in otherwise, you can understand on the basis of a Shabarimala's case. In this particular case, the ideology is very different. Even in some places, you can Tamil Nadu, Andhra, ಕೆಲವೊಂದು ಪ್ಲೇಸ್ಗಳಲ್ಲಿ ಹೋದ್ರೆ ದೇವಸ್ಥಾನಗಳಲ್ಲಿ ಗಂಡಸರನ್ನ ಬಿಡೋದಿಲ್ಲ ಅಂತ ದೇವಸ್ಥಾನಗಳು ಇದಾವೆ ಅಲ್ವಾ. ಕೆಲವೊಂದು ದೇವಸ್ಥಾನಗಳಲ್ಲಿ ಗಂಡಸರೇ ಮಾತ್ರ ಹೋಗ್ಬೇಕು ಅಂತ ದೇವಸ್ಥಾನಗಳು ಇದಾವೆ. ಯಾಕೆ ಇಲ್ಲಿ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ ಅಂದ್ರೆ, ಒಂದು ಇನ್ಸ್ಟೆನ್ಸ್ ಇಟ್ಕೊಂಡು ಏನೋ ಒಂದ್ ರೀತಿಲಿ ಏನೋ ಈ ದೇಶದಲ್ಲಿ ಆಗಿದೆ ಅನ್ನಲ್ಲ, ಏನೋ ಒಂದ್ ಕಡೆಗೆ ಹಿಂದಿ ಇರ್ತಕ್ಕಂಥ ಆಚಾರ ವಿಚಾರ ಅಥವಾ ಪರ್ಸೆಪ್ಷನ್ಸ್ ಗಳಿಗೆ ಮನುಷ್ಯ ಇವತ್ತು ಬದುಕ್ತಾ ಇದ್ದಾನೆ. ಇಲ್ಲ ಅಂತ ಹೇಳಿ ನಾವು ಬಿಟ್ಟು ಬದುಕೋಕ್ಕೂ ಆಗೋದಿಲ್ಲ, ಏನೇ ಸೈನ್ಸ್ ಅಂಡ್ ಟೆಕ್ನಾಲಜಿ ಬಂದಾದ್ರೂ ಕೂಡ. ಸೊ ಇವೆಲ್ಲ ಇದಾವೆ. ದೀಸ್ ಆರ್ ದ ಪರ್ಸೆಪ್ಷನ್ಸ್ ಯು ಶುಡ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ದಟ್ಸ್ ವೈ I appreciate the propositions made by Hegel, Kant, David Hume in connection to their theory called as a will theory as such. Look at interest theory, which was actually emphasized by Eyring. He says that a legal right is a legally binding interest. Yes, it is legally binding. All interests should be legally binding. ಈ ಪರ್ಸೆಪ್ಷನ್ ಬಾಬಾ ಸಾಹೇಬ್ ಅಂಬೇಡ್ಕರ್ದು ಹಾಗೆ ಇತ್ತು. ಕೇವಲ ನೀವು ಮಾರಲ್ ರೈಟ್ಸ್ ಅನ್ನ ನೀವು ಹೇಳಕ್ ಆಗೋದಿಲ್ಲ. ಮಾರಲ್ ರೈಟ್ಸ್ ಅನ್ನ ಕೆಲವೊಬ್ರು ಬಂದಿರ್ತಕ್ಕಂಥ ಆಚಾರ ವಿಚಾರಗಳಿಂದ ಅವನು ಒಪ್ಕೋಬಹುದು. ಬಹುಶಃ ಅವನು ಏನಾದ್ರು ಬೇರೆ ರೀತಿಯಲ್ಲಿ ಇದ್ರೆ ಅವನು ಒಪ್ಕೊಳಕ್ ಆಗೋದಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಅವ್ರು ಏನ್ ಇನ್ಸಿಸ್ಟ್ ಮಾಡಿದ್ರು ಅಂತಂದ್ರೆ, ನೀವ್ ಏನೇ ಕಾನೂನು ಮಾಡಿ ಅದನ್ನ ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಬರ್ರಿ. ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಇದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಅವನಿಗೆ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಅನುಕೂಲ ಆಗುತ್ತೆ, ಅವಕಾಶಗಳು ಇರ್ತವೆ. ಯಾರೋ ಕಾಮೆಂಟ್ರೀಸ್ ಬರ್ದಿದ್ದನ್ನ ನೀವು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. ಸೊ ಹಾಗಾಗಿ ಕಾನೂನನ್ನ ಮಾಡ್ಬೇಕಾದ್ರೆ ಸರಿಯಾಗಿ ಶಾಸ್ತ್ರೋಕ್ತವಾಗಿ ಧರ್ಮಾಧಾರಿತ, ಅಂದ್ರೆ ಧರ್ಮ ಅಂದ್ರೆ ಏನು, ಒನ್ ಓಸ್ ಡ್ಯೂಟಿ ಟುವರ್ಡ್ಸ್ ಅಷ್ಟೇ. ಬೇರೆಗೆ ಯಾವ ರೀತಿ ಒಂದು ನ್ಯಾಯಯುತವಾಗಿ ನ್ಯಾಯಸಮ್ಮತವಾಗಿ ಅವನಿಗೆ ದೊರಕಿಸ್ಕೊಡ್ಬೇಕು ಅನ್ನೋ ಮಟ್ಟದಲ್ಲಿ ಕಾನೂನನ್ನ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಇಲ್ಲ ಅಂತಂದ್ರೆ ಏನಾಗ್ತದೆ ಅಂದ್ರೆ, ಸಣ್ಣ ಪುಟ್ಟಕ್ಕೆಲ್ಲ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕಾಗ್ತದೆ, ಕಚೇರಿ ಹೋಗ್ಬೇಕಾಗ್ತದೆ. ಎಷ್ಟು ವರ್ಷ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ? ನೀವು ಬಾಬ್ರಿ ಮಸೀದಿ ಕೇಸನ್ನ 63 ವರ್ಷ ತಕೊಂಡ್ರಿ. ಎಷ್ಟು ವರ್ಷ ತಕೊಂಡ್ರಿ? ಸಣ್ಣ ಕೇಸ್ ಅದು, ಅದೇನ್ ದೊಡ್ಡ ಕೇಸ್ ಏನಲ್ಲ. ಒಂದು ರಿಲಿಜನ್ ಮೇಲೆ ಇರ್ತಕ್ಕಂಥ ಕೇಸ್ ಅದು, ಅಂತ ದೊಡ್ಡ ಕೇಸ್ ಏನಿಲ್ಲ. ಇಟ್ ಟುಕ್ ಆಲ್ಮೋಸ್ಟ್ 63 to 65 years country like India. So hagagi something has to be looked upon, as I believe. So rights andaga neevu we have had different perceptions on rights. Like we have positive rights, negative rights, proprietary rights, personal rights, legal rights, equitable rights, primary rights, sanctionary rights, public and private rights, then servient rights and dominant rights. The rights and concept alli tumba theories ಗಳಿದಾವೆ, perceptions ಗಳಿದಾವೆ, ideologies ಗಳಿದಾವೆ. I agree with you.
Sir, namaste.
Yeah.
Slides move ಆಗ್ತಾ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ sir.
1 minute. Okay, is it okay?
Yes sir.
Yeah, thank you. Of course, no doubt. Along with the continuity of these specific theoretical perceptions, we have natural law theory, labor theory, then metaphysical theory, psychological theory, and such other theories are there with you to understand what is right. Here, my perceptions are one and the same. I agree with you when you are just sharing with the intellectual property rights are concerned. What are intellectual property rights? How will you understand intellectual property rights? Intellectual property rights are legal rights given to the inventor or a creator. ಆತ ಅವನ ಬುದ್ಧಿಶಕ್ತಿಯಿಂದ ಬೌದ್ಧಿಕ ಹಕ್ಕು ಅಂತ ಕರಿತೀವಿ ನಾವು. ಬೌದ್ಧಿಕ ಸ್ವಾಮ್ಯದ ಹಕ್ಕುಗಳು ಅಂತ ನಾವು ಕರಿತೀವಿ ಇಂಟೆಲೆಕ್ಚುಯಲ್ ಪ್ರಾಪರ್ಟಿ ರೈಟ್ಸ್ ಅಂದ್ರೆ. ಅವನ ಬುದ್ಧಿವಂತಿಕೆ ಬಂದಿರ್ತಕ್ಕಂಥದ್ದು, ಬೇರೆ ಎಲ್ಲೋ ಇಲ್ಲಿಂದಲ್ಲ. ಈಗ ನಿಮಗೆ ಡಿಸ್ಕವರಿಗೂ ಇನ್ವೆನ್ಷನ್ಸ್ಗೂ ಡಿಫರೆನ್ಸ್ ಇದೆ, ಅದು ಎರಡನ್ನು ಮಿಕ್ಸ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. ಸೊ ಆ ನಿಟ್ಟಿನಲ್ಲಿ ಯಾವ್ಯಾವ್ದು ಇನ್ವೆನ್ಷನ್ ಬರುತ್ತೆ, ಕ್ರಿಯೇಷನ್ ಆಫ್ ಮೈಂಡ್ ಅಲ್ಲಿ ಬರುತ್ತೆ, ಅವೆಲ್ಲ ಹಕ್ಕುಗಳನ್ನು ನಾವು ಇಂಟೆಲೆಕ್ಚುಯಲ್ ಪ್ರಾಪರ್ಟಿ ರೈಟ್ಸ್ ಅಂತ ಕರಿತೀವಿ, ಬೌದ್ಧಿಕ ಹಕ್ಕುಗಳು ಅಂತ ಕರಿತೀವಿ. Intellectual property rights have their roots in Europe, especially European countries. Granting patents started in 14th century. Yes, we have got our own history with you to understand, intellectual property rights are concerned. The copyrights appeared in Italy. I'll go through it. What are copyrights? Patents, industrial designs, integrated circuits, then geographical indications. ನೀವು ಜಿಯೋಗ್ರಫಿಕಲ್ ಇಂಡಿಕೇಶನ್ಸ್ ಅನ್ನ ಸುಮಾರು ನೋಡಿರ್ಬೋದು. ಲೈಕ್ ಮದ್ದೂರ್ ವಡೆ ಇರ್ಬೋದು, ಮೈಸೂರು ಸಿಲ್ಕ್ ಸ್ಯಾರಿ ಇರ್ಬೋದು, ಕೂರ್ಗ್ ಆರೆಂಜ್ ಇರ್ಬೋದು, ಚಾಂಪಿಯನ್ ವೈನ್ ಇರ್ಬೋದು, ಆಮೇಲೆ ಧಾರವಾಡ ಪೇಡೆ ಅವೆಲ್ಲ ಇರ್ಬೋದು. These are the geographical indications. They are indicated on the basis of soil. You know very well, philosophically, soil has a capacity to eat you, though you have not been known, isn't it? You have no capacity to eat soil, but soil has a capacity. Please understand the philosophical foundations as well. This is one thing. On the other hand, as and when you deal with intellectual property rights, there are some perceptions. Please understand. They are actually derived and established on the basis of a Eurocentric approach, United States centric approach, Asia-Afrocentric approach, Asian and African centric approaches. So why I'm sharing all these examples, there is a relevance from the standpoint to understand intellectual property rights of these sectors are concerned, especially in US. Whatever they look, IPR is entirely different from Asian and African countries are concerned. This is my understanding, and one of the hypothetical answers I'm just sharing with you. If you are closer to temperature, the high fertility will come. When you have got high fertility, population will be increased. When you got population, problems are quite common all over the world. You go to any country in the world, you go to any country in the world, you will find all these differences and understandings. Therefore, I must acknowledge certain definitions in connection to the subject matter of right as well. Please understand how, in what manner right can be defined. On par with the developments that are taken place through their own checks and balances are concerned. Look at J.S. Mill. What he says, your rights have derived and established on the basis of value of utility. On the other hand, Henry Maine in the United Kingdom, Karl van Savigny in Germany, they say that your rights have borrowed from the cultural variables. It is always depending on cultural variables, and you have to understand on the basis of earlier history as well. Take for an example, civilization. What is civilization? What we do is our civilization, whereas what we for is our culture. You should understand culture and civilization. Look at the Mesopotamian civilization, Harappa Mohenjo-daro civilization, Indus Valley civilization, Greek civilization, Roman. All in all, you will have known how exactly rights have borrowed and come from. That's why I must share with you. You should understand where exactly you have come from. Then only you appreciate yourself. Where are you going? This is very, very important from the point of view of understanding the rights which are derived and established in the given situation as such. Look at earlier history was entirely different. Isn't it? We couldn't find a patent, copyright, integrated circuits, designs, and all in all. People were copying directly from the law of nature. Now it is restricted because of individual rights. This is very, very important from the point of understanding the intellectual property rights are concerned. Here, you have to understand moral and legal rights. What are moral rights and legal rights? How exactly you are going to balance the interest between moral and legal rights? You know very well, better than me, that the moral rights are actually derived from the natural law philosophy, whereas legal rights have come from positive approaches, the positive theory as such. The positive theory has given you some inputs to understand legal rights as well. So therefore, here when it comes to the knowledge of the intellectual property rights, first of all, you have to understand the sources of information based on the law as such. Without understanding the basis of law, it's very difficult to understand what is the intellectual property right. So therefore, as and when you deal with the intellectual property rights so long, you shall not be forgotten on moral and legal rights are concerned. This is one of the observations I have when it comes to the knowledge of intellectual property rights are concerned. In fact, intellectual property rights are nothing but the rights given to individuals based on their invention and the creation. The right to protect the property that is created by our mind, it has been defined as idea. I mean to say creative inventions, creations of mind, such as inventions, literary, artistic work, then designs, symbols, names, images, words, and phrases as well. You just look into any blog in internet, you will have known how exactly intellectual property rights would be protected, who has to protect any infringement of copyright or something else, and where exactly you are going to build the cat. This is very, very important from the point of understanding IPR. In fact, IPR provide certain exclusive rights to the inventors and creators of that property in order to enable them to reap commercial benefits from their creative efforts and their reputation as well. You have to protect their creativeness and the reputation as well. This is very, very important. I cannot copy your, a book in which you have already been written. It is clear violation of the copyright as well. Like, plagiarism. Nima book inda nanu direct aga copy madakagudilla. Adu plagiarism violation ಆದಂಗಾಗುತ್ತೆ. ಈಗ UGC 2018 ಅಲ್ಲಿ ಪ್ಲೆಜರಿಸಮ್ ಗೈಡ್ಲೈನ್ಸ್ ಅನ್ನ ಕೊಟ್ಟಿದ್ದಾರೆ. ನೀವು ನೋಡಿ ಗೊತ್ತಾಗ್ತದೆ. ಅಲ್ಲಿ ಏನಾದ್ರು ಒಂದು ವೇಳೆ ಪ್ಲೆಜರಿಸಮ್ ಅಂದ್ರೆ ಕೃತಿ ಚೌರ್ಯ ಅಂತ ಕರೀತಾರೆ. ಅದೇ ಒಂದ್ ವೇಳೆ ಮಾಡಿದ್ರೆ ವಿಲ್ ಬಿ ಪ್ರಾಸಿಕ್ಯೂಟೆಡ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಅಂಡ್ ಯಾರಿಗೆ ವೈಲೇಷನ್ ಆಗಿದೆ ಅವರು ಕಾಂಪನ್ಸೇಷನ್ ಅನ್ನ ನಿಮ್ಮಂದ ಕೇಳ್ಬೋದು. ಅಷ್ಟು ಹಕ್ಕು ಅವರಿಗೆ ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ. ಹಿಂದೆ ಏನಾಗ್ತೈತಿ ಅಂದ್ರೆ ಯಾರ್ ಬೇಕಾದ್ರೂ ಕಾಪಿ ಮಾಡ್ಬೋದಾಗಿತ್ತು. ಎಷ್ಟೋ ಬುಕ್ಗಳನ್ನ ಕಾಪಿ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೀವಿ ನಾವು, ಬಾರೋ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೀವಿ. ಇದೆಲ್ಲ ಇದೆ. These are the things shall also be looked into. Look at the intellectual property protection includes patents, copyrights, trademarks, geographical indications, then trade secrets, for example, designs, semiconductor integrated circuits, layout designs, traditional knowledge, plant breeders rights and all. ಈಗ ಟ್ರೆಡಿಷನಲ್ ನಾಲೆಜ್, ಟ್ರೆಡಿಷನಲ್ ನಾಲೆಜು ಕೂಡ ನಮಗೆ ನಾವು ರಕ್ಷಣೆ ಮಾಡ್ಕೋಬೇಕಾಗ್ತದೆ. ಉದಾಹರಣೆಗೆ ಈಗಾಗಲೇ ನೋಡಿ ನಮ್ಮ ದೇಶದಲ್ಲಿ ನಾವು ಇಂಟೆಲೆಕ್ಚುಯಲ್ ಪ್ರಾಪರ್ಟೀಸ್ ಬಗ್ಗೆ ಸಾಕಷ್ಟು ಮಾತಾಡಿದೀವಿ, ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ. ಆದ್ರೆ ಡಾಕ್ಯುಮೆಂಟೇಶನ್ ನಾವು ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ ಇದುವರೆಗೂ. ನಿಮ್ಮನ್ನ ಯಾರೋ ತಗೊಂಡ್ರು, ಬಾಸ್ಮತಿ ರೈಸ್ ಅನ್ನ ಯಾರೋ ತಗೊಂಡ್ರು. ಸೊ ಹೀಗೆ ಕಾಟನ್, ಟ್ರೆಡಿಷನಲ್ ಕಾಟನ್ ಯಾರೋ ತಗೊಂಡ್ರು, ಟ್ರೆಡಿಷನಲ್ ಬ್ರಿಂಜಾಲ್ ಅನ್ನ ಯಾರೋ ತಗೊಂಡ್ರು. ಸೊ ಇವೆಲ್ಲ ನೋಡಿ ಈಗ, ಯಾಕಂದ್ರೆ ನಮ್ಮಲ್ಲಿ ಸರಿಯಾಗಿ ಪ್ಲಾಂಟ್ ವೆರೈಟೀಸ್ ಎಷ್ಟಿದೆ ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಕಾಡಿಗೆ ಹೋಗಿ ನೋಡಿದಾಗ ಗೊತ್ತಾಗ್ತದೆ ಎಷ್ಟು ಪ್ಲಾಂಟ್ ವೆರೈಟೀಸ್ ಇದಾವೆ, ವಾಟ್ ಆರ್ ದ ಯೂಸಸ್ ಆಫ್ ದೀಸ್ ಪ್ಲಾಂಟ್ಸ್ ಅನ್ನೋದು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕಾಗ್ತದೆ. ಅಂಡ್ ಯು ನೋ ವೆರಿ ವೆಲ್, ಬೆಟರ್ ದ್ಯಾನ್ ಮೀ, see our western gods have got their own plant varieties. The western god has given life to every one of them. Flora irbodu, fauna irbodu, ಸಾಕಷ್ಟು ಗಿಡಮೂಲಿಕೆಗಳು ಅಲ್ಲಿ ಇದಾವೆ. ಅವ್ರನ್ನ ನಾವು ರಕ್ಷಣೆ ಮಾಡ್ಬೇಕಾಗ್ತದೆ ಇವತ್ತಿನ ಕಾಲದಲ್ಲಿ. ಉದಾಹರಣೆಗೆ ಸೇ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ನಮ್ಮಲ್ಲಿ ಸಾಕಷ್ಟು ವರದಿಗಳು ಬಂದಿದ್ದಾವೆ. ಈಗ ಉದಾಹರಣೆಗೆ ಮಾಧವ ಗಾಡ್ಗಿಲ್ ರಿಪೋರ್ಟ್ ಇರ್ಬೋದು, ಕಸ್ತೂರಿ ರಂಗನ್ ರಿಪೋರ್ಟ್ ಇರ್ಬೋದು, ಅಥವಾ ಓಮನ್ ಚಾಂಡಿ ರಿಪೋರ್ಟ್ ಇರ್ಬೋದು. ಸಾಕಷ್ಟು ರಿಪೋರ್ಟ್ಸ್ ಗಳು ಬಂದಿದ್ದಾವೆ ವೆಸ್ಟರ್ನ್ ಘಾಟ್ಸ್ ಮೇಲೆ. ನಾವು ಕೂಡ ವೆಸ್ಟರ್ನ್ ಘಾಟ್ಸ್ ಮೇಲೆ ರಿಸರ್ಚ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗಿದ್ದೀವಿ, ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ. ಆದ್ರೆ ಎಷ್ಟು ಮಟ್ಟಿಗೆ ನಾವು ಈ ವೆಸ್ಟರ್ನ್ ಘಾಟ್ಸ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂತ ಗಿಡಗಳನ್ನ, ಅಲ್ಲಿರ್ತಕ್ಕಂಥ ಮರಗಳನ್ನ ನಾವು ರಕ್ಷಣೆ ಮಾಡಿದೀವಿ ಅನ್ನೋದು ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟ್. ಹೌ ಎಕ್ಸಾಕ್ಟ್ಲಿ ಬಯೋಡೈವರ್ಸಿಟಿ ಶುಡ್ ಬಿ ಪ್ರೊಟೆಕ್ಟೆಡ್ ಅಂಡ್ ಡಾಕ್ಯುಮೆಂಟೆಡ್. This is what the Protection of Biodiversity Act 2002 is very clear. This has to be looked into. ಅದನ್ನೆಲ್ಲ ನೋಡ್ಬೇಕಾಗ್ತದೆ. ಸೊ ಹಾಗಾಗಿ ಇಂಟೆಲೆಕ್ಚುಯಲ್ ಪ್ರಾಪರ್ಟಿ ರೈಟ್ಸ್ ಇಟ್ಸ್ ಅ ಬ್ರಾಡರ್ ವಿಷನ್. ಅದು ಒಂದು 1 hour ಅಲ್ಲಿ ನಮಗೆ ಎಲ್ಲದನ್ನು ಕನ್ವೆ ಮಾಡಕ್ಕಾಗಲ್ಲ. Somehow I can try my level best to convey the certain aspects in connection to intellectual property rights in nutshell as well. Look at the copyrights. These were actually appeared in Italy. Venice can be considered as a cradle of intellectual property system. The Patent Act in India is more than 150 years old as such. These are the aspects which shall also be looked into. There are some examples. You just go through them. What are intellectual property rights? Intellectual property rights are nothing but patents, domain names. You can have your own domain name based on your own creation. Patents, industrial designs. It's up to you to decide. ಯಾವ ಡಿಸೈನ್ ಅಲ್ಲಿ ಮಾಡ್ತೀರಾ ಅದನ್ನ, ಆ ಡಿಸೈನ್ ಅನ್ನ ನೀವು ಬೇಗ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾಡ್ಕೋಬೇಕಾಗ್ತದೆ, ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೋಬೇಕು ಇಮಿಡಿಯೇಟ್. ಹಾಗೆ ಬಿಟ್ರೆ ಇನ್ನೊಬ್ಬರು ಬೇರೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಬಿಟ್ರೆ that has to go to his rights as well. Immediately you should do that. Then confidential information. How exactly confidential information should be protected? Your inventions, moral rights, database rights, work of authorship, service marks, then logos, trademarks, design rights, business and trade names, commercial secrets, and computer software. This is what you should understand it. See, intellectual properties have come from different backgrounds. Might be based on economic imperialism or something else. I agree with you. However, you may have gone through some criticisms leveled against intellectual property rights. Look at the creation of mind and invention. So all these things like creation of mind and to say invention, so should be protected by whom? The state should protect. That's why as many as laws have come through with a view to understand the intellectual property rights as well. So you can put a fundamental question on intellectual property rights in otherwise manner. See, what are the rationale behind for the protection of intellectual property rights? Why intellectual property rights should be encouraged and protected? Of course, no doubt there are some benefits of intellectual property rights. You can encourage invention. By encouraging invention, you can protect, intellectual property rights as well. The legal protection of new creations, which encourages the commitment of additional resources for further innovation. Man is very funny. See, when an apple fell down, he felt something. Oh, it was because of a gravitational force. It might have, fell down. This is one of the observations we have. When some, scientists, when they saw that oscillating bell, they found that the heliocentric approach. Look at Galileo's heliocentric approach. It was an observation. When Archimedes dumped into bathing tub, he saw loss of water. That was his observation. Look at the Newton's third law of motion, equal and opposite direction. These were, expressive with a view to understand the scientific temperament of a human being. Look at the creation of mind. They have not come from artificial life. They have come from natural life as well. You have to understand it. Everything is actually based on his own efforts and ideas and inventions as well. Look at Einstein approaches. Then Leonard Darwin's approaches on writing of some paintings. So these are the things that shall also be encouraged. By encouraging invention, you can protect their intellectual property rights as well. Look at economic growth. The promotion and protection of intellectual property rights spur economic growth, which creates new jobs and industries and enhances the quality and the enjoyment of the life as well. Therefore, they are benefited. You can also safeguard the rights of a creator. Intellectual property rights is required to safeguard creators and other producers of their intellectual commodity, goods, services by granting them certain time-limited rights to control the use made of the manufactured goods, and it promotes invention and creativity and encourages ease of doing business as well. And in a silver linings, in fact, it facilitates the transfer of technology in the form of a foreign direct investment, joint ventures, and licensing. See, transfer of technology is one of the debatable issues. Country like India as such. You know very well, better than me. See, always the developing countries demanding to have technology from developed countries. How they can transfer? It's debatable. If you have got technology, how can you transfer it? Unless there is a license or a non-disclosure agreements. So therefore, it is encouraging all aspects in a daily life of a human being as such. As I said, it facilitates the transfer of technology in the form of foreign direct investment, joint venture, and licensing. Let me share with you, in 1960 and 1970, there was an awareness among these developing countries. In fact, in nutshell, I can say that in 1960 and 1970, you could establish new international economic order. Why new international economic order came forward? See, new international economic order came forward with a view to target developed countries. This is very, very important. So in 1947, GATT was established. It took almost all the 3 decades to understand the problems of developing countries. So that's why Group 77 countries or third world countries in 1960 and 1970, they stood somewhere and started questioning developed countries as well. Then they knew the problems between developed and developing countries, especially in Marrakesh Agreement and roundtable conferences of trade-related services all over the world, especially through WTO, that the World Trade Organization. Through World Trade Organization, we could establish somehow harmony between developed and developing countries as well. Of course, this is a debatable issue. I agree with you. However, you have to understand the relationship between states as well, based on their foreign policies. Based on foreign policies, you have to understand the relationship between these states as well. Otherwise, it's very difficult to understand, peace and security all over the world as such. So therefore, you have to understand on the basis of these factors, how exactly intellectual property rights are benefited. This is one thing. On the other hand, why intellectual property rights came forward? Look at trade-related intellectual property rights. There was an agreement between states themselves with you to protect the creation of mind or invention of the individuals who have come from different laws of different countries as well. So with these few aspects, WTO, that the World Trade Organization, came forward with some action plans with you to protect the intellectual property rights as well. Therefore, you have to understand all these factors based on the developments that are taken place on the basis of international level. Look at the importance of intellectual property right was actually first recognized in a Paris Convention. Paris Convention for the Protection of Industrial Property, 1883. Then Berne Convention for the Protection of Literary and Artistic Work, 1886. Of course, both treaties are administered by World Intellectual Property Organization. We have a World Intellectual Property Organization, which is one of the specialized agencies of United Nations Organization as such. This World Intellectual Property Organization was set up on the basis of the ongoing negotiations at the higher level as such. So take for example the World Trade Organization as well. So these are the things shall also be looked upon with you to understand the intellectual property rights as well. Okay, you have copyrights, designs, geographical indications, layout designs, integrated circuits, variety of plants, information technology, cyber crimes, data protection. So these are the issues are there with you to understand the intellectual property rights as well. We have got few specific legislations which are addressing the issues of intellectual property rights. They talk about definition clause and how exactly the respective rights shall be protected, any infringement of their rights, what is to be done, and where exactly you can knock the doors of judiciary, how exactly the remedies would be given, and what is the stay of action, and how, in what manner, certain compensation would be given to the people who are left out in the society as such. So therefore, the parliament took a very good decision to pass all these legislations with you to protect and promote or increase the human rights of these people, which are highly expressive under Article 27 of International Covenant on economic, social, and cultural rights in 1966 as well. India is one of the member countries of these, and India is known for its international relations based on Article 51 and 253 of the Constitution of India. And moreover, if rather I would say, the constitutional validity of public international law has already been known to us. It is not new to us. It is there under Article 253 of the Constitution of India. This is one thing. On the other hand, of course, no doubt, there is a common misconception prevailed in the Indian judicial system to the effect that international covenants are not supposed to be enforceable unless and until you should have had a specific legislation or an enactment. This is the caption we have. However, Supreme Court of India came out with some classical theoretical observations. Take for example, they could be on this of transformative theory or delegation theory. Based on transformative and delegation theory, we could share on the basis of the developments that are taken place at the higher level as such. These are the things that shall also be looked upon. See, whatever we have gone through the legislations, these legislations have been actually passed by the parliamentary, and we have shown our interest at the international level. Look at Trademarks Act 1999, then the Patents Act 1970, which was amended in 2005, the Copyright Act 1957. You just go through any book written by you or anybody, okay, you will find a Copyright Act 1956 over there. Disclaimer, you have to ಯಾವುದೇ book ಅಲ್ಲಿ ನೀವು book ಅನ್ನ ಪಬ್ಲಿಕೇಶನ್ ಮಾಡಬೇಕಾದ್ರೆ ಡಿಸ್ಕ್ಲೈಮರ್ ಇರಲೇಬೇಕಾಗ್ತದೆ. ಯಾಕಂದ್ರೆ ನಿಮ್ಮ ಬುಕ್ ಅನ್ನ ಬೇರೆಯವರು ಕಾಪಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಒಂದ್ ವೇಳೆ ಮಾಡಿದ್ರೆ ಪ್ಲೆಜರಿಸಮ್ ಆಗುತ್ತೆ. You have got all rights to file a case against them, whoever may be copied. ಯಾರೇ ಕಾಪಿ ಮಾಡಿದ್ರು ಕೂಡ ನಿಮಗೆ ಹಕ್ಕಿರುತ್ತೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಯಾವ್ದು ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ ತಗೊಂಡ್ರು ಕೂಡ ಪ್ಲೆಜರಿಸಮ್ ಈಗೆಲ್ಲ ತುಂಬಾ ಸ್ಟ್ರಾಂಗ್ ಆಗಿದೆ. Shoes composition you have to pay to them, so you have to be careful while you are citing some books in your book or report, anything for that matter. ಯಾವುದೇ ಕಾಪಿರೈಟ್ ನೀವು ಹೋಲ್ಡರ್ ಆಗ್ಬೇಕಾದ್ರೆ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ನೀವು ಬಹಳ ಕೇರ್ ಆಗಿರ್ಬೇಕಾಗ್ತದೆ. ಆಮೇಲೆ ಡಿಸೈನ್ ಆಕ್ಟ್ 2000 ಯಾವ ಡಿಸೈನ್ ಅಲ್ಲಿ ಇದೆ, ಲೈಕ್ ಏರೋಪ್ಲೇನ್ ಯಾವ ಡಿಸೈನ್ ಅಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದೀರಾ, ನಿಮ್ ಕಾರ್ ಯಾವ ಡಿಸೈನ್ ಅಲ್ಲಿ ಇದೆ, ಸ್ಕೂಟರ್ ಯಾವ್ದು ಡಿಸೈನ್ ಅಲ್ಲಿ ಇದೆ, ನಿಮ್ ಸ್ಕೂಟರ್ ಯಾವ ಸೌಂಡ್ ಇದನ್ನು ಕೂಡ ಇಂಪಾರ್ಟೆಂಟ್, ಶೇಪ್ ಹೆಂಗಿದೆ, ನೀವು ಯಾವ್ದೋ ಒಂದು ಸ್ಯಾರಿ ಡಿಸೈನ್ ಮಾಡಿದ್ರೆ ಯಾವ ಡಿಸೈನ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಸ್ಯಾರಿನ, ಯಾವ ಅಪ್ರೋಚಸ್ ಅಲ್ಲಿ ಇದೆ, ಎಲ್ಲದನ್ನು ನೀವು ಕಾಪಿ ಮಾಡಕ್ ಬರಲ್ಲ. ತಕೊಂಡು ನೀವು ಅದೇ ಡಿಸೈನ್ ಅನ್ನ ನೀವು ಹೈಯರ್ ರೇಟ್ ಅಲ್ಲಿ ನೀವು ಮಾರ್ಕೆಟ್ಗೆ ಬಿಡಕ್ ಬರುತ್ತಿಲ್ಲ ಯಾವುದೇ ಕಮಾಡಿಟಿ. It is totally prohibited. You have to be careful when you are designing something. Then geographical indication of goods, which is actually dealing with the registration and protection of the geographical indication of goods, 1999 as well you have. Then protection of plant varieties and farmers rights act 2001 as well. ಈಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಈಗ ಪಾಲಿ ಹೌಸ್ ಇರ್ಬೋದು, ಯಾವ್ದು ಈಗ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ಅಪ್ ಸ್ಟ್ಯಾಂಡ್ ಅಪ್ ಮುಖಾಂತರ ಸಾಕಷ್ಟು ಪ್ರಾಜೆಕ್ಟ್ಸ್ ಗಳನ್ನ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಗೌರ್ಮೆಂಟ್ ತುಂಬಾ ಫಂಡ್ಸ್ ಅನ್ನ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಅದು ಏನ್ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ನಾವು ಎಲ್ಲ ಒಂದ್ ಕಡೆಗೆ ಪ್ಲಾಂಟ್ ವೆರೈಟೀಸ್ ಅನ್ನ ಬ್ರೀಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಸೊ ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ನೀವು ಬಹಳ ಕೇರ್ ಆಗಿ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಒಂದ್ ವೇಳೆ ಮಾಡ್ಲಿಕ್ಕೆ ಹೊರಟ್ರೆ ನಿಮ್ದೇ ಇನ್ವೆನ್ಷನ್ ಫಸ್ಟ್ ಆಗಿದ್ರೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ನೀವು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಇಂಟೆಲೆಕ್ಚುಯಲ್ ಪ್ರಾಪರ್ಟಿ ರೈಟ್ಸ್ ಅಲ್ಲಿ ಒಂದು ಗಮನದಲ್ಲಿ ಇರ್ಬೇಕು ಅಂದ್ರೆ ನೀವ್ ಏನೇ ಒಂದು ಪೇಟೆಂಟು, ಕಾಪಿರೈಟು, ಡಿಸೈನು ಅಥವಾ ಪ್ಲಾಂಟ್ ವೆರೈಟೀಸ್ ಬಗ್ಗೆ ರಿಸರ್ಚ್ ಮಾಡ್ಬೇಕಾದ್ರೆ, ಇನ್ವೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ನೀವು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿಸ್ಕೋಬೇಕು. ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿಸ್ಕೊಂಡ್ಮೇಲೆ ನಿಮಗೆ ಒಂದು ಡೊಮೈನ್ ನೇಮ್ ಅದೆಲ್ಲ ಸಿಗುತ್ತೆ. ಅದಾದ್ಮೇಲೆ ಯು ವಿಲ್ ಬಿ ಅ ಹೋಲ್ಡರ್ ಆಫ್ ದಟ್ approaches. Otherwise it's very difficult. Then Information Technology Act 2000 is also dealing with protection of intellectual property rights as well. Look at patents. Let's have a discussion on patent, isn't it? Design patents anta ide, plant patents anta ide, utility patents anta ನಾವು ಮೂರು ಡಿಸೈನ್ ಅಲ್ಲಿ ನಾವು ಪೇಟೆಂಟ್ಸ್ ಗಳನ್ನ ನೋಡ್ತೀವಿ. ಉದಾಹರಣೆಗೆ ಪ್ರೊಟೆಕ್ಷನ್ ಫಾರ್ ದ ಆಸ್ಥೆಟಿಕ್ ಅಂದ್ರೆ ಆಸ್ಥೆಟಿಕ್ ಅಂದ್ರೆ ಲವ್ ಆಫ್ ಆರ್ಟ್ ಅಂದ್ರೆ ಅದ್ ನೋಡಿದ ತಕ್ಷಣ ನಿಮ್ಗೆ ಏನೋ ಒಂಥರ ಇದಾಗುತ್ತೆ. ಸೊ ಹಾಗೆ ಎಮೋಷನಲ್ ಅಬ್ಸರ್ವೇಷನ್ಸ್ ಇರ್ತಕ್ಕಂಥ ಡಿವೈಸ್ ಇರ್ಬೋದು ಅಥವಾ ಇನ್ವೆನ್ಷನ್ಸ್ ಇರ್ಬೋದು. ಆರ್ನಮೆಂಟಲ್ ಡಿಸೈನ್ ಪೇಟೆಂಟ್ಸ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ಪ್ರಾಡಕ್ಟ್ಸ್ ಶೇಪ್ ಇರ್ಬೋದು. ಕೋಕೋ ಕೋಲಾ ಬಾಟ್ಲ್ ಹೆಂಗಿರ್ಬೇಕು ಅಂತ, ಬಾಟ್ಲ್ ಶೇಪನ್ನು ಕೂಡ ನೀವು ಕಾಪಿ ಮಾಡಕ್ ಆಗುದಿಲ್ಲ. ಯಾವ ಬಾಟ್ಲ್ ಹೇಗಿರ್ಬೇಕು ಅನ್ನೋದು ಗೊತ್ತಿರ್ಬೇಕು. ಶೇಪ್, ಕಲರ್, ಯಾವ ಕಾರಲ್ಲಿ ನಿಮ್ದು ಡಿಸೈನ್ ಮಾಡಿದೀರಾ, ದಟ್ಸ್ ಇಂಪಾರ್ಟೆಂಟ್. ಎಮೋಜಿಸ್ಗಳು, ನೀವು ಎಮೋಜಿಗಳನ್ನ ಕಳಿಸ್ತಾ ಇರ್ತೀರಿ ಈಗ ಟೆಕ್ಸ್ಟ್ ಮಾಡಿದಾಗ, ಅವಾಗ ಯಾವ ರೀತಿ ಎಮೋಜಿ ಕಳಿಸಿದ್ರು ಅದು ಕೇರ್ಫುಲ್ ಆಗಿರ್ಬೇಕಾಗ್ತದೆ. ದೆನ್ ಫಾಂಟ್ಸ್ ಯಾವ್ದಿದೆ, ಎನಿ ಅದರ್ ಡಿಸ್ಟಿಂಕ್ಟ್ ವಿಜುವಲ್ ಟ್ರೇಟ್ಸ್. ಡಿಸ್ಟಿಂಕ್ಟ್ ವಿಜುವಲ್ ಟ್ರೇಟ್ಸ್ ಅಂದ್ರೆ ನಿಮ್ಮ ಇನ್ವೆನ್ಷನ್ಗೂ ಬೇರೆ ಇನ್ವೆನ್ಷನ್ಗೂ ತುಂಬಾ ಡಿಸ್ಟಿಂಕ್ಟ್ ವಿಷನ್ ಇದ್ರೆ ಮಾತ್ರ ನಿಮ್ಗೆ ರೈಟ್ಸ್ ಸಿಗುತ್ತೆ. ಸಿಮಿಲರ್ ಇದ್ರೆ ನಿಮಗೆ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ. ಇಟ್ ಇಸ್ ಟೋಟಲಿ ಪ್ರೊಹಿಬಿಟೆಡ್ ಆಸ್ ಫಾರ್ as design patents are concerned. Then plant patents, look at it, safeguards for the new varieties of plants. An example of plant patent is pest free versions of fruit trees irbodu. But invention, investors may also want to design patients if the tree has a unique visual visual properties are concerned. Then utility patents anta ide. ಉದಾಹರಣೆಗೆ intellectual property examples ಕೊಡ್ಬೇಕಾದ್ರೆ which includes vehicle safety system ಇರ್ಬೋದು. ಯಾವ ರೀತಿ ನೀವು ವೆಹಿಕಲ್ ಅನ್ನ ಅದು ಡಿಸೈನ್ ಮಾಡಿದೀರಾ, ಲೈಕ್ BMW, ಬೆಂಜೋ, ಆಡಿ ಇರ್ಬೋದು ಅಥವಾ ಫೆರಾರಿ ಇರ್ಬೋದು, ಲ್ಯಾಂಬರ್ಗಿನಿ. ಕೆಲವೊಂದು ಆಕ್ಸಿಡೆಂಟ್ಸ್ ಗಳನ್ನ ಅವಾಯ್ಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಇರುತ್ತೆ. ಅಷ್ಟು ಲೆವೆಲ್ ಅಲ್ಲಿ ಅದನ್ನ ಡಿಸೈನ್ ಮಾಡಿದ್ವಿ, ಅದನ್ನ ನೋಡ್ಬೋದು. ದೆನ್ ಯಾವ ಸಾಫ್ಟ್ವೇರ್ ಇದೆ, ಪ್ಯಾರಾಮೆಸಿಟಿಕಲ್ಸ್, ಯಾವ ಮೆಡಿಸಿನ್ ಇದೆ, ದಟ್ಸ್ ಆಲ್ಸೋ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ನಿಮಗೆ IP ಅಂತ ಇಂಡಿಯನ್ ಫಾರ್ಮಾಸ್ಯೂಟಿಕಲ್ ಅಂತ ಇರುತ್ತೆ, US ಫಾರ್ಮಾಸ್ಯೂಟಿಕಲ್ ಅಂತ ಇರುತ್ತೆ, ಯುರೋಪಿಯನ್ ಫಾರ್ಮಾಸ್ಯೂಟಿಕಲ್, ಅದೆಲ್ಲ ನಿಮಗೆ ಅಲ್ಲಿ ಐಡೆಂಟಿಫಿಕೇಶನ್. And this was the first and still the largest area for the patent law country like India. ಯಾವುದು ಯುಟಿಲಿಟಿ ಪ್ಯಾಟೆಂಟ್ಸ್ ಅನ್ನ ನಾವು ಜಾಸ್ತಿ ಎಕ್ಸ್ಪೋಸ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಸ್ಪೆಸಿಫಿಕಲಿ. ದಿಸ್ ಒನ್ ಥಿಂಗ್. ಲೆಟ್ ಅಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಟ್ರೇಡ್ ಮಾರ್ಕ್. Trademark, the protection of distinguishing marks, recognition of service mark, then indefinite periodical renewals of registration, abolition of compulsory licensing. ಅದೆಲ್ಲ ಬರುತ್ತೆ. ಲೈಸೆನ್ಸಿಂಗ್ ಎಲ್ಲ ಬರುತ್ತೆ. ಯಾವ ರೀತಿ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಬೇಕು, if something has gone wrong, what is to do. All in all, we have. See, when you are sharing few aspects in connection to the subject matter of copyright. ಕಾಪಿರೈಟ್ ಅಲ್ಲಿ ನಾವು ಮೂರು ಡಿವಿಷನ್ ಅಲ್ಲಿ ನೋಡ್ತೀವಿ. ಉದಾಹರಣೆಗೆ ಆರ್ಟಿಸ್ಟಿಕ್ ವರ್ಕ್ಸ್, ಕಂಪ್ಯೂಟಿಂಗ್, ದೆನ್ ಬಿಸ್ನೆಸ್. ದೇರ್ ಆರ್ 3 divisional. Can you please mute yourself? Yeah, thank you. Artistic works, computing, business. In artistic works, you will be finding novel, lyrics, poem, sound recording, movie, ಪೇಂಟಿಂಗ್, ಪ್ಲಾನ್ ಆಫ್ ಬಿಲ್ಡಿಂಗ್. ಈಗ ನೀವು ಕಾಂತಾರ ಸಿನಿಮಾ ನೋಡಿದಿರಲ್ಲ, ನೋಡಿದೀರಾ? ಸೊ ಅದರಲ್ಲಿ ಒಂದು ಕಾಂಟ್ರವರ್ಸಿ ಬಂತು. ಯಾವುದೋ ಒಂದು ಹಾಡನ್ನ ಇಲ್ಲಿ ಕಾಪಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ. It is questioned under Copyright Act 1957. So this is actually to be protected. Yes, I agree. ಯಾವ್ದೋ ಒಂದು ಕಾಪಿ ಮಾಡ್ಕೊಂಡು ನಾವು ಕಮರ್ಷಿಯಲ್ ಗೇನ್ ಮಾಡೋದಿದೆಯಲ್ಲ, it is against to the intellectual property rights as well. Then computing, especially computing, you can find in a software application and programming. So whatever you have had some programming should be protected. That business copyright we have, like database, annual reports, business proposals, business plan. ಈಗ ಉದಾಹರಣೆಗೆ ನಿಮ್ ಕಂಪ್ಯೂಟರ್ ಪಾಸ್ವರ್ಡ್ ಕೊಡ್ಲಂಗೆ ಇದೆಲ್ಲ ಡೇಟಾ ಪ್ರೊಟೆಕ್ಷನ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ ಅಂದಿದ್ರೆ ತುಂಬಾನೇ ಕಷ್ಟ ಆಗ್ತದೆ. ನಿಮ್ಮ ಏನು ಡೇಟಾ ಬೇಸ್ ಇರ್ಬೋದು, ಆನ್ಯುಯಲ್ ರಿಪೋರ್ಟ್ಸ್ ಇರ್ಬೋದು, ಬಿಸ್ನೆಸ್ ಪ್ರಪೋಸಲ್ಸ್ ಇರ್ಬೋದು, ಬಿಸ್ನೆಸ್ ಪ್ಲಾನ್ ಗಳನ್ನ ಯಾರೋ ಒಬ್ರು ಕಾಪಿ ಮಾಡ್ಕೊಂಡು ಕಮರ್ಷಿಯಲ್ ಯೂಸ್ ಅನ್ನ ಮಾಡ್ಕೋಬಹುದು. These are the issues we have. So when you are sharing few observations in connection to the subject matter of protection of patents, there are so many things are there. I'm just giving you some examples, like an aeroplane, then mold board plow you have, then light bulb, then telephone, 3D printer irbodu, then electric car irbodu, iPhone. So how exactly these inventions or creations should be protected? This is very, very important. On the other hand, as and when you deal with trademarks, trademarks have got their own applications. Take an example, then McDonald, then Nike head and shoulder shampoo irbodu, ಅದು ಸ್ಮೆಲ್ ಅನ್ನು ನೋಡ್ಬೇಕಾಗ್ತದೆ, ಕಲರ್ ಅನ್ನು ನೋಡ್ಬೇಕು. ಅದನ್ನ ಹಾಗೆ ನಿಮ್ಮ ಏನು ಹೆಡ್ ಅಂಡ್ ಶೋಲ್ಡರ್ ಶಾಂಪೂ ತಗೊಂಡು ಬೇರೆಯವರು ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ತಮ್ಮ ಟ್ರೇಡ್ ಮಾರ್ಕ್ಸ್ ಅನ್ನ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ. ಇಟ್ಸ್ ಟೋಟಲಿ ಪ್ರಾಹಿಬಿಟೆಡ್. ದೆನ್ ಬ್ರ್ಯಾಂಡ್ ನೇಮ್ಸ್ ಇದೆ, ಪ್ರತಿಯೊಂದು ಬ್ರ್ಯಾಂಡಿಗೂ ಒಂದು ನೇಮ್ ಇರುತ್ತೆ. ಲೈಕ್ ಲೂಯಿ ಫಿಲಿಪ್ ಇರ್ಬೋದು, ವ್ಯಾನ್ ಇಷನ್ ಇರ್ಬೋದು, ಪೀಟರ್ ಇಂಗ್ಲೆಂಡ್ಗೆ ಒಂದು ನೇಮ್ ಇದೆ. ಸೊ ಹಾಗೆ ನೈಕ್ ಶೂಸ್ ಇರ್ಬೋದು, ಬಾಟಾ ಶೂಸ್ ಇರ್ಬೋದು, ಅಥವಾ ಹಸ್ ಪಪೀಸ್ ಇರ್ಬೋದು. ಏನೆಲ್ಲ ನೀವು ತಗೊಳ್ತಿರಲ್ಲ ಮಾರ್ಕೆಟ್ ಅಲ್ಲಿ, ಪ್ರತಿಯೊಂದಕ್ಕೂ ಟ್ರೇಡ್ ಮಾರ್ಕ್ ಇದೆ. ನೀವು ಯಾವುದೇ ಮಾಲಿಗೆ ಹೋಗಿ, ಮಾಲ್ ಆಫ್ ಮೈಸೂರ್ಗೆ ಹೋಗಿ, ಓರಿಯನ್ ಮಾಲಿಗೆ ಹೋಗಿ, ಗರುಡಾ ಮಾಲಿಗೆ ಹೋಗಿ, ಪ್ರತಿಯೊಂದಕ್ಕೂ ಡಿಸ್ಟಿಂಗ್ವಿಶ್ಡ್ ಟ್ರೇಡ್ ಮಾರ್ಕ್ ಇದ್ದೇ ಇರುತ್ತೆ. ನೀವು ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ, ಅದನ್ನ ನೋಡ್ಕೊಂಡ್ರೆ ನೀವು ತಗೋಬೇಕಾಗ್ತದೆ. ಇದೊಂದು. ದೆನ್ ಪ್ರಾಡಕ್ಟ್ ನೇಮ್ಸ್ ಇದೆ, ಸ್ಲೋಗನ್ಸ್ ಇರುತ್ತೆ, ಕಲರ್ ಇರುತ್ತೆ, ಸೌಂಡ್, ಶೇಪ್, ಯಾವ ಶೇಪ್ ಅಲ್ಲಿ ಇದೆ, ಯಾವ ಕಲರ್, ಸೌಂಡ್ ಹೇಗ್ ಮಾಡುತ್ತೆ, ನೀವು ಎನ್ಲಿ ಫೀಲ್ಡ್ ಯಾವ ಸೌಂಡ್ ಅಲ್ಲಿ ಇದೆ, ಅದು ಯಾವ್ದೋ ಒಂದು TVS ತಕೊಂಡ್ರು ಯಾವ ಸೌಂಡ್ ಅಲ್ಲಿ ಇದೆ, ಕಾರಲ್ಲೂ ಕೂಡ ಸೌಂಡ್ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗಿರುತ್ತೆ. ಸೊ ಅದೆಲ್ಲ ನೋಡ್ಬೇಕಾದ್ರೆ ಆ ಬೇಸಿಸ್ ಮೇಲೆ ನಿಮಗೆ ಟ್ರೇಡ್ ಮಾರ್ಕ್ ಕೊಡ್ತಾರೆ. ದೆನ್ ಫೆಸಿಲಿಟೀಸ್, ಏನೇನ್ ಫೆಸಿಲಿಟೀಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ, ದಟ್ಸ್ ಆಲ್ಸೋ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಪವರ್ ವಿಂಡೋ ಇದೆಯೋ, ಮ್ಯಾನ್ಯುಯಲ್ ವಿಂಡೋ ಇದೆಯೋ, ಅಥವಾ ಯಾವ ರೀತಿ ನೀವು ಡಿಸೈನ್ ಮಾಡಿದ್ದೀರಾ ಕಾರನ್ನ, ಆ ಬೇಸಿಸ್ ಮೇಲೆ ನಿಮ್ಗೆ ಕೊಡ್ಬೇಕು. ಅದ್ರ ಜೊತೆಗೆ ಕಾಂಬಿನೇಷನ್ ಇಸ್ ಆಲ್ಸೋ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ವೆನ್ ಯು ಆರ್ ಜಸ್ಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಟ್ರೇಡ್ ಮಾರ್ಕ್ಸ್ ಆರ್ ಕನ್ಸರ್ನ್. Like copyrights, look at copyright. You deal with painting, sculpting, drawing, engraving, photography, artistic craftsmanship, dramatic work, literary work, musical work, sound recording, then cinematography. All these things should be brought within the limits of the copyrights as well. So with these a few aspects, in fact, I take this opportunity to thank each one of you for giving this opportunity to share few views on intellectual property rights and concepts. In nutshell, I can say that intellectual property rights are actually respected to promote and increase invention and the creation of mind as well. His creation and the mind should be protected on the basis of humanity as well. So earlier question were actually different. Now it has come to us with you to protect our own rights from external issues are concerned. With these few aspects, I take this opportunity to thank once again all the very best. If you have got some questions in connection to intellectual property rights, I'm actually answerable to your questions. Over to you. If you have got some questions, you can. Of course, no doubt, in recent the past, we have had as many as the developments that are taken place through the science and technology as such. Look at nanotechnology, information technology, cyber technology, digital technology, marine technology, all in all have come through. I agree with you. However, it is the right time to understand the creation of mind, the work which has been actually designed by somebody else, that has to be protected. So look at the artificial intelligence and machine learning in these days. It is upcoming like anything. Artificial intelligence and machine learning is also upcoming. Then a robotic process automation is also upcoming. Then edge computing, quantum computing, virtual reality and augmented reality is also upcoming. Then the blockchain, as you have already been understood, blockchain is also there. Internet of Things, 5G, and the cyber security as well. Since you are finding all these developments through the creation of mind, obviously, I must share with you, you have to understand how, in what manner, intellectual property rights should be protected through certain specific legislations as well. Otherwise, it's very difficult to understand the new technology trends in 2022 as well. So look at the artificial intelligence. It's coming like anything. Everybody wants to have artificial intelligence. Even in research also. Even in research, people are demanding to have artificial intelligence. I don't know how exactly artificial intelligence will be helpful. No matter, artificial intelligence has had its own limitation. I agree with you. Yes, isn't it? You cannot dump everything into a computer and get all information immediately, isn't it? So therefore, as long as you are looking forward in this so long, you shall not be forgotten on the humanity as such. I must share with you, being a teacher, science means humanity, technology means humanity. So science and technology, they should go hand in hand for the betterment of a human being as well. So with these a few aspects, we have to uphold the constitutional values and the morality as well. Without understanding constitutional values and morality, whatever you are inventing or creating yourself, would be incomplete, and they are actually contrary and contradictory meaning with the law of nature as such. So therefore, at the end, I can say that you have to grow naturally how plants and trees are growing. That's very, very important. And don't be an artificial when you are just making some specific legislations as well. I must believe that if rather I would say an artificial life shall be condemned, has to be condemned. I agree with you. And moreover, if rather I would say an egoistic person will never ever die because he has no human body as such. When he has not been actually known with the human body, this is actually somewhat quite common all over the world. It could be Eurocentric approach, US-centric approach, and Afro-centric approach as well. So with these a few aspects, once again, I take this opportunity to thank each one of you for your patient hearing. Thank you very much. If you have got some questions, I'm happy to answer you.